Next witnesses are Daniel Marotta and Allyn Crawford of the Richmond County Bar Association.
Good afternoon to the commission and judges and lawyers and members of the public that are here on this important issue. My name is Daniel Marotta, and I'm president of the Richmond County Bar Association, association of over 500 attorneys. With me here today is our vice president, Allyn Crawford.
Good afternoon.
I've been an attorney for over 20 years, and for 20 years I've been reading and researching cases, real estate, commercial litigation, estate litigation, and areas that I practice. And it's a tough job to be an attorney, especially an honest attorney. I volunteer my time for pro bono efforts whenever I see a cause that's worthy, and I do it regularly. Strict enforcement of the disciplinary rules and prosecution of disciplinary charges are in the best interest of honest lawyers and protect the public. And this is true. The integrity of the profession is at stake, and I can't compete with lawyers who treat escrow accounts like their own personal piggy banks. This escrow problem we've heard over and over again today obviously must be addressed by this commission. And I do want to say, however, that we need to make sure that we have a system that's fair and balanced to everyone involved. And to increase the efficiency of this system and achieve dispositions more quickly, any complaints that are false or unfounded on their face must be weeded out and discouraged from clogging the system. There are many complaints that come in. In fact, a great majority of them that are simply unfounded. Some of them are just simple misunderstandings between client and attorney. Others are more egregious. Sometimes the complainant may not have standing. Matrimonial cases were mentioned before. I think this is an area where this issue is particularly important. Sometimes you'll see a husband will file a complaint against the wife's attorney. It's conduct that could be described as malicious. And I've been a New Yorker my whole life. I don't think anyone here is naive to think that people will not file complaints that are not true or have allegations that are just false. It happens all the time. It is a real problem. And a lot of these complaints that come in have to be dealt with administratively. The attorney must answer them. And so how do we address this? Because for the honest lawyer, there's severe ramifications. And for all attorneys that are involved, the severe ramifications. If a client or a complainant files a complaint against a lawyer that is false, they have nothing to lose. Oftentimes, these statements are unsworn. They're written on a letter or a napkin even. We should require the statements that are submitted and answers given by lawyers must be notarized, sworn statements under penalties of perjury. Like this is a basic requirement that we should make sure is enforced strictly. We should also, in an effort to try to weed out some of these unfounded complaints, have a minimum filing fee, maybe $100, something that would be an exception only where the client met financial eligibility requirements, in which case there would be no fee or it would be waived, or in cases involving theft of escrow funds, in which case there would be no fee. By imposing some fee, I think that a great deal of these complaints that seem to have no real basis would be weeded out, and you would see a huge decrease in them automatically. Also, sometimes, as we have heard over and over again from our members, that the complaints are often, in fact, used as a bargaining strategy. Legal fees are outstanding, they haven't been paid, and suddenly, instead of a phone call, you get a disciplinary complaint. And the appellate divisions and departments know and sometimes recognize that the complaint, although it's labeled as a grievance, is really a fee dispute, and we'll refer it to our fee arbitration panel. But there is no way of telling when it first is filed. Now, for the attorney, the ramification is that your reputation is at stake, and your malpractice insurance premium is going to increase whether this complaint ever results in disciplinary charges or not, whether this complaint was false, or whether it was totally unfounded or filed by for some malicious purpose. Your malpractice insurance premiums will increase. I don't see how we could publish this type of defamatory comments or defamatory charges against an attorney where there's been no discipline or finding of misconduct. The medical profession does the same thing. These complaints and these proceedings are not made public. The information is not published and republished until there's a finding of wrongdoing. This, again, protects the honest attorney who's been the subject of an unscrupulous complaint. With respect to regional disparities that the Commission is also looking at, and we heard a speaker earlier this morning say that we have a judicial system of resolving complaints among citizens, and we have a system for attorney discipline. Our judicial system is based on the fact that there are different departments, and local litigants are entitled to have local judges hear their complaints in a county in which they reside. This is our system. It's not to say that it's a disparity is a misnomer. Each locality will have a different set of concerns, a different set of issues that those persons in that locality know how to deal with.
We have approximately 3 minutes left. I'm not sure the intention is for your colleague to speak as well.
Mr. Crawford's going to add a couple of statements. My last statement I'd like to point out is for Richmond County Bar Association, for a few years now, we've started a volunteer lawyers program, and it's based on examples from other sister bar associations, and we've attempted to protect the public from the unauthorized practice of law. We've provided competent legal services for families who can't afford them, and I feel that these efforts sometimes are stymied when we're here to discuss issues that might be perceived as an attack on lawyers. While I understand that there are serious and egregious cases, we can't let examples of bad apples be the catalyst to restructure our entire framework that has worked for some time and undoubtedly could use improvement.
Thank you. I in large part, would be repeating Mr. Marotta's comments if I spoke at length. But the real concern of our association and of the lawyers that Dan and I represent is that if a complaint immediately becomes public or goes into a process where it's reviewed by the public without there being any controls on that to determine whether there's any validity to it, to a small practitioner who are the practitioners that we represent. I mean, my firm has 4 lawyers in it, Dan's firm has 4 or 5 lawyers in it, and we might have 2 of the bigger firms in Richmond County. These are sole practitioners, and their real bread and butter in the community is their relationship with the community and their reputation. And our concern is that if there's a complaint that immediately becomes public, it goes out there, it could be utterly unfounded, and then that lawyer, his means of making a living, his livelihood, then becomes something which could be, tarnished without there being any control on that. And it's a real concern for our membership. I think it's a concern for the bar at large, and I think it should be a concern for this committee.
Thank you.
Thank you.
Mr. Zahn.
Thank you. Let me give you an opportunity to address something which is kind of the heart of what you're saying. Underlying much of the discussion about attorney discipline is the premise or assumption that, which is often true, that the lawyer is in a position of strength vis-a-vis the client, and we have to guard against and appropriate cases, punish appropriately and severely cases where the trust in that relationship has been abused. But I usually have been practicing for more than 20 years, practicing for more than double that, and in various bar posts and in practice, and talking with lawyers in private practice, including I'm sure many on Staten Island. There's a situation which often goes unaddressed because a complaint never gets filed, which is unfair to the lawyer as well, which is the fee dispute that you referred to. You know, there are many clients that are much more powerful than the lawyer who is representing them. That's a fact. Business people who are well-heeled may say to a lawyer, I don't want to pay your bill. If you're going to insist on that, I'm going to file a complaint with the disciplinary committee. Now, the lawyer faces a situation in which the lawyer basically has to give up, even though the work was earned, and just give in to that because of the things that you suggest. And if we open up the disciplinary process fully, that lawyer has to contemplate, does he or she not, that simply because they ask for payment, they're going to have a disciplinary complaint against them, and all the public things that that go along with that. Now, I've seen many, many cases of that, and I just want to bring into the discussion so that we look at all aspects of this, that phenomenon. Is that something that you've encountered as president of your association?
Well, we've heard this over and over again, and as I said, the disciplinary committee will refer it to the fee arbitration panel if they can discern that the complaint is really about money. Of course, the problem is the damage is done. In terms of, when you renew your malpractice insurance policy, when you come to that question, has there ever been a complaint filed against you? Do you have any reason a complaint would ever be filed against you or any member of your firm or any member of any prior firm you've ever been involved with? These questions become more and more broad. You have to check yes. Now you have to attach an explanation page, and of course it's simply a cost that comes to the attorney. And for the attorney who prides himself or herself on their reputation, it's devastating. It's just devastating, especially in a community like Staten Island, where 500 attorneys, it's not that many.
Does the mechanism of the fee dispute resolution preclude the complainant from making a complaint that's of record in the disciplinary committee?
No, I don't believe it does, but it provides the client with a venue in which they can arbitrate or try to facilitate a resolution of that claim. I think that's something that, in my understanding, is a lot of times if a complaint comes into the appellate division on an attorney and it's reviewed by appellate division staff, they'll, rather than publish it as we think we might do, send it out to our local bar grievance committee, and then that grievance committee will then attempt to resolve the issue between the litigant and the lawyer, and they're successful, whether through fee arbitration or through something else. So I think that's incredibly helpful to the bar and to the people we serve, and it avoids what we're looking to avoid.
Mr. Marotta and Mr. Crawford, in your view, should the attorney disciplinary system be opened at all? And if so, at what stage?
At the stage when there's been a finding of misconduct against the attorney, that results in the imposition of discipline against that attorney.
So in other words, when the appellate division has imposed public discipline, is that your view?
Yes. Same as the medical profession.
Yes.
Thank you, gentlemen, for your testimony. I just want to address your association's recommendation that we impose a $100 fee on the filing of a complaint. I want to give you the opportunity to address that, because one of the things that we would do as a body making recommendations, and one of the things that any rulemaking body does when they're considering changing the rules is they have to ask themselves who benefits from the rule change and who suffers detriment. I'd be interested, from your point of view, is if we're imposing a $100 fee on complainants, who's benefiting and who's suffering detriment? And have you considered the possibility that the $100 fee could chill the filing of legitimate complaints?
Yes, I did. As I said, if the complainant was screened for financial eligibility, the fee could be waived. The imposition of the fee would serve everyone's interests. The imposition of the fee, I do not believe, would chill legitimate complaints. A legitimate, serious complaint against an attorney, I don't think will be chilled by a requirement that a fee of $100 be paid. This requirement of this fee, I believe, benefits everyone. I believe it benefits the attorney that's being charged with a serious matter. I think it kind of imposes some seriousness to the proceeding. And I think also I have heard that many complainants do not cooperate very well with the disciplinary committee when it comes to scheduling and rescheduling and meeting deadlines. So I think the imposition of the fee will, if you will, put some skin in the game for the complainant. And again, if it's someone that can't afford it, then we can address that. And if it involves escrow theft, this escrow theft must be dealt with strictly, and I believe there should be an exemption for complaints that involve escrow theft.
Thank you very much for your testimony.
Thank you.